Okay, yeah.
How are you?
John Bruce, nice to meet you. Thank you for coming in. Speak. There you go. Try to clip on, make sure that's what you're working on. I hear it. I know it's working.
Good evening. My name is Jack Priscilla. Thanks for coming. First off, an update about Father Horn. He had the bypass surgery this morning. He's breathing on his own. The doctors are very pleased, and it went as normal as it could. So the doctors and the nurses and the whole team did their job. They cut, but God heals. So I think we should start with a prayer of thanksgiving to our Heavenly Father for being with the surgeon's team, being with Father Horn, and now heal him as fast as he can, totally, and get him back here as quickly as he can. God bless. So our speaker tonight is the epitome of the American dream. Started from nothing, all the talent in the world, hard work, everything that's made America great. And became a lawyer, and then decided he wanted to serve, public service. And worked his way up, and now he's one of our Michigan Supreme Court justices. His name is Justice Brian Zahra. So thank you for coming, welcome, and please.
Okay. Well, good evening, everyone, and thank you so much. I am very pleased to have this opportunity to speak to you tonight. I've given many talks in my career. Most speeches have been to a room full of lawyers over a dinner at which there was a cocktail hour where people could enjoy a cocktail or two or three. This puts people in a very good mood. And of course, these are perfect conditions for delivering a speech. Lawyers with alcohol in their system are generally welcoming and open to judicial discourse. Tonight, however, I'm truly challenged. I've neither lawyers nor alcohol working for me. And to make matters much worse, I must deliver my remarks to a crowd awe-stricken at their last meeting by the space travels of an astronaut. This is truly a tough assignment. Nonetheless, I'll do my very best to keep you entertained, and hopefully you will go home this evening with something profound to think about. I'm here tonight because I'm a friend of Jack. And when you are a friend of Jack Crisula, anything is possible. Jack once asked me in a way that only Jack can. He tilted his head down, his eyes staring through his forehead at me, and he said, "Justice. Of all the enumerated rights in the Bill of Rights, which one is your favorite?" That's indeed a difficult question. There are so many rights to choose from. But, as I will explain, not as many as James Madison wanted us to have. Think about our nation, if you will, at the time of the founding. We had just defeated the British Empire. You would think we'd be a joyous and united nation. But the war took a great toll. The Continental Congress was broke and in disarray. The Army, which had not been paid for more than a year, contemplated a military coup. The Articles of Confederation were woefully inadequate. The Congress had no authority to raise capital through taxation. It relied on states to give it money, and many of the states just chose not to give any money. Further, there were no laws providing for the regulation of commerce between the states. Thus, many of the founders thought it was critical and imperative to enact a constitution that would give substantial power to a federal government. But not all the states were enamored with this. Patrick Henry was an outspoken and articulate anti-federalist. He feared a federal government that would be too powerful. I hear people complain all the time about the lack of civility in political debate today. But the debate whether to ratify our Constitution was often uncivil, and perhaps worse than the discourse of today. The anti-federalists had great momentum. They feared that the federal government would be too powerful and take rights away from the people and the states. To counter these arguments, James Madison promised that if the states would just ratify the Constitution, his first duty would be to propose a Bill of Rights to protect the people. The Constitution was indeed ratified, and in the first Congress, Madison lived up to his promise, proposing 20 amendments as our Bill of Rights. Madison's list was reduced to 17 by the House of Representatives, and the Senate took the axe to 5 more. The 12 remaining proposed amendments went to the 13 original states for ratification. But as we all know, the Bill of Rights consists of the first 10 amendments to our Constitution. Interestingly, the first 2 amendments were not ratified by the requisite 10 of the original 13 states. The original First Amendment would have changed how members of the House of Representatives were apportioned. But the states didn't view the apportionment of representatives as a civil liberty that belonged in the Bill of Rights, and this amendment failed. Defeat of the original Second Amendment was really critical and important to the members of the First Congress, as it concerned their pay. The amendment barred Congress from giving itself a pay raise without first having stood for re-election by the people. In this way, representatives who felt themselves worthy of a pay raise would have to answer to the people before benefiting from an increase in compensation. Only 9 of the original 13 states ratified this proposed amendment, so it was not included in the Bill of Rights. Interestingly, however, in 1982, a University of Texas student by the name of Gregory Watson was conducting research for a paper he was writing for his government class. Watson originally planned to write about proposed amendments to the Constitution that were never ratified. Upon a close reading of Madison's originally proposed Second Amendment, Watson realized that it was still alive. That is, there was no language in it that closed the window for ratification. Watson rightfully believed this was a remarkable and amazing fact, and he made this discovery the focus of his paper. Watson fully expected to receive an A on his research paper, but the teaching assistant grading the papers wasn't so impressed, and he got a C. Outraged that his historic discovery was not better rewarded, Watson appealed the grade to the professor. But on appeal, the C stood. So insulted by the grade was young Gregory Watson that he decided to lead the charge to ratify the amendment. Having had 9 states ratify it in 1791, the amendment fell 1 state short of ratification. But with 50 states now in the Union, the amendment needed 38 states for ratification. This meant that Watson had to persuade 29 additional states to ratify this nearly 200-year-old amendment, an amendment originally drafted and proposed by James Madison. Watson wrote to state after state and was met with rejection after rejection until Maine agreed with him and ratified it in 1983. Watson cited his success in Maine to get other states to consider ratification, and they did. After 9 years of work, 35 states had ratified it, leaving Watson just 3 states shy of his quest to prove his professor wrong. On May 5, 1992, Alabama and Missouri ratified it. And 2 days later, on May 7, 1992, the great state of Michigan voted for ratification, making it the 27th and last amendment to our United States Constitution. Watson's professor, Sharon Waite, had no idea Watson had pursued this action in response to the grade she gave him. With the benefit of hindsight, Professor Waite admitted Watson deserved an A+. And in March of 2017, the University of Texas officially changed Watson's transcript to award him an A+ in government. And that is how the original Second Amendment became the 27th Amendment to the United States Constitution. I share this story of Madison's original Second Amendment because I find it quite remarkable and amazing that for nearly 200 years, people wrongly assumed this amendment was dead. And all it took was an ambitious young college student to change how people looked at this amendment and ultimately changed our Constitution. And I believe there are some generally accepted assumptions about the separation of church and state that are held by many. And perhaps if we look at the First Amendment with a fresh perspective, people might think differently about the separation of church and state. But before I get to that, it's important to look at the history of religion in America to give context to why James Madison provided religious protection in the First Amendment. I know historical accounts can be boring, but please bear with me. I promise to tie it all together. As we all know, English colonial expansion in America started in the 1600s. Many of the colonists that left England left in the face of religious persecution. But the Crown had its own agenda in allowing these colonists to establish life on the other side of the Atlantic. For the most part, English colonies in North America were business ventures for the King of England. King James divided the Atlantic seaboard into pieces and gave them to people who would advance the trade interests of England and pay a tax back to the king. The first English immigrants to what would become the New England colonies were a small group of Puritan separatists, those we all know as Pilgrims. They arrived in 1620 to found Plymouth Colony. Shortly thereafter, a much larger and more liberal group of Puritans established another Massachusetts settlement. And as the Massachusetts settlements expanded, new colonies were formed, primarily for religious reasons. Puritans who thought Massachusetts was not pious enough formed the colony of Connecticut. And Puritans who thought Massachusetts was too restrictive formed the colony of Rhode Island, which eventually became a refuge for people of diverse religious views. To the north of Massachusetts Bay Colony, a handful of adventurous settlers formed the colony of New Hampshire, which became a Congregationalist colony. Catholics, who were harassed and persecuted in England and Ireland throughout the 1600s, eventually moved to the United States to form the colony of Maryland. In 1632, George Calvert, a Catholic, obtained a charter from King Charles I to establish this colony. The Maryland Charter offered no guidance on religion, although it was assumed that Catholics would not be harassed there. But Catholic tolerance waned in Maryland during the rest of the 1600s as Catholics became an increasingly smaller portion of the population. In 1664, King Charles II gave his brother James, the Duke of York, territory between New England and Virginia, and this area was occupied by Dutch and other northern settlers. This territory was named New York after the Duke of York, and most of the people living there stayed put, which made New York one of the most religiously and culturally diverse colonies in the land, a trait still held by New York today. In 1680, King Charles II granted land west of the Delaware River to William Penn, a Quaker. He founded Pennsylvania. Lured by the fertile soil and the promise of religious toleration, people immigrated there from all over Europe. The southern colonies developed at a slower pace and grew more through economic development rather than a search for religious freedom. As a result, most of the southern colonies were occupied by Anglicans. Surprising to me as I did my research was the fact that religious persecution existed in the colonies. That is, while many colonists left England to free themselves from religious persecution, 8 of our original 13 colonies featured some form of state-sponsored religion. Typically, all inhabitants of a particular colony paid taxes to promote the state-sponsored church, and most of these colonies had restrictive rules or laws forbidding participation in the government if one was not practicing the actual state-endorsed religion. What is clear, though, is regardless of religious persuasion, the colonists of the 1600s were devoutly religious people, and their passion for faith increased in the 1700s. Historians estimate that between 1700 and 1750, 75 to 80% of the population regularly attended church services. And churches were built at a rapid pace, increasing in number by over 500% in the 1700s. Clearly, the colonists were, by and large, a devoutly religious people. Notwithstanding this, there is a school of thought that many of our influential founding fathers, including Washington, Jefferson, Franklin, Paine, Madison, and Monroe, were deists. Deism grew out of the Enlightenment movement that flourished in Europe in the 1700s. The Enlightenment was a European intellectual movement focused on reason and individualism rather than tradition. It emphasized that people should believe only in things that can be proven through reason and logic, and rejected religion and matters of faith as things that constrained mankind in the Middle Ages. Deists believe that a supreme being created the universe and established rationally comprehensible moral principles. But deists do not believe that God intervenes in human affairs. Deism is not an organized religion. Therefore, even among deists, there is great disparity in the beliefs. The movement's most radical wing viewed Christianity as a barrier to moral improvement and social justice. Other deists, though, tried to reconcile deism with Christianity and utilized Christian values to guide them in their daily affairs. Whether all of these founding fathers were deists is far from clear. To the contrary, my research suggests that only Thomas Paine was a deist, as he was openly hostile to Christianity. Franklin, in his young days, embraced deism, but with maturity he rebuked deism and became an active member of the First Presbyterian Church of Philadelphia. As for Washington, Madison, Monroe, and Jefferson, there's no concrete evidence that they were in fact deists. To the contrary, evidence suggests that each was a practicing Christian and a member of the Anglican Church. Washington, Jefferson, and Madison were vestrymen in that church. The vestry is essentially the equivalent of the parish council. Washington was the only founding father who went to war against the British. He was often observed praying before battles. The phrase, there are no atheists in foxholes, can be traced back to World War I. But based upon the historical accounts of Washington, I would submit there are no deists in foxholes during the American Revolution. James Madison was raised in the Anglican Church, but he attended the Presbyterian College of New Jersey, which later became known as Princeton. There, Madison studied theology. Although an ardent Anglican, Madison was a staunch advocate for the free exercise of religion and opposed to state-endorsed religions. We should expect nothing less from the author of our First Amendment. Additionally, Washington, Jefferson, and Monroe were also strong opponents of state-endorsed religion. State-endorsed religion actually proved to be the source of most religious conflict in early America. Charles Carroll of Carrollton, Maryland, exemplifies this. Charles was a Catholic and the last surviving survivor to sign the Declaration of Independence. Charles was one of the most devout founding fathers. He was cousin to John Carroll, the first Catholic bishop and archbishop to serve in the United States. John Carroll also founded George Washington University, the oldest Catholic university in the United States. Charles' father fled Ireland due to religious persecution of Catholics. He settled in Maryland, where Catholics were initially free to practice their faith. But as I said, as more of the Anglicans inhabited Maryland, there became less tolerance for Catholics. The Anglican Church became the state-endorsed church, and Catholics were barred from voting or holding public office. Members of the Carroll family had amassed a good bit of wealth and property in Maryland, yet, as a result of their faith, they were treated as second-class citizens. Charles' father wanted his son to have superior upbringing and an excellent education, giving him all the ability he needed to compete with the Protestant majority. If you think about it, with their wealth and intelligence, the Carroll family could have quickly moved up the ranks of the Maryland leadership had they simply converted to Anglicanism. Many Maryland Catholics did, but the family was adamant that their religious allegiance was not for sale. So at age 10, Charles was sent to France to be educated by Jesuits. He eventually studied law in London and returned home at 26. Throughout that 16-year period, he enjoyed only one visit from his family. When Charles ultimately returned to Maryland, he took over his father's 10,000-acre estate. Charles proved to be an effective manager of the estate, but like his father, he remained barred from political activity due to his faith. In 1770, though, the political climate of Maryland provided Charles an opportunity. The Maryland Assembly was divided over fees paid to officers of the Crown. The lower house wished to drastically reduce these fees, and the upper house, members who were appointed by the Crown, wanted to hold firm. Unable to reach common ground, the royal governor, also appointed by the king, declared an impasse and announced that the fees would continue. Charles Carroll commenced writing editorials in opposition to the fees in the Maryland Gazette. His intellect and reasoning were displayed to all of Maryland, and Charles quickly found favor with the Protestant masses. The Protestants viewed these fees as acts of tyranny. As an unsettled population rose in protest, the royal governor was eventually forced to evacuate, and Charles Carroll was named to the Maryland Committee of Safety, a committee appointed to replace the royal governor. In February of 1776, Charles was appointed by the Continental Congress to join Samuel Chase and Benjamin Franklin for a diplomatic trip to Quebec to seek support for the American Revolution. Later in 1776, Charles was named to the Maryland delegation to the Continental Convention, where he was influential in getting passed a resolution calling for a formal separation from Great Britain. He worked successfully to have the Maryland Assembly rescind its instructions to delegates to oppose independence. And on August 2nd, 1776, Charles signed the Declaration of Independence, the only Catholic to do so. It should be no surprise that the religious beliefs of our founders were as varied as their political views. There were Quakers, Presbyterians, Puritans and Methodists, Baptists and Mennonites, Lutherans and Jews. There were Calvinists, and there were Catholics, and many, many more. In the early stages of our new nation, it was not uncommon for people to come to blows in the streets over politics. But make no mistake, none of these fights started because one advocated that public policy should reflect the moral and religious values of the nation. Our founders were passionate about their religious beliefs and the country that they helped found. Their religious value system was integrated into the foundation of this nation. Were they perfect? Absolutely not. They were inflicted with the imperfections of humanity. There was the abomination of slavery, which was permitted to continue far too long. Slavery existed throughout the world then, and sadly, it continues in our world today. It was eventually abolished, but only with the passage of time, many, many political fights, and a bloody and horrific civil war. Women were initially denied the right to vote, but eventually afforded that right. And civil rights for all Americans were guaranteed through our Constitution and our laws. But these imperfections, serious as they are, should not diminish from the accomplishments of their time. Our founding fathers created a country like no other in the history of the world. Our foundational principles are immutable and lasting. They have flourished and they have withstood the test of time. Our founders declared independence from Great Britain by observing that they were entitled to assume the separate and equal station to which the laws of nature and of nature's God entitles them. They further declared, "We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain inalienable rights, that among these are life, liberty, and the pursuit of happiness." The Declaration of Independence was a revolutionary document, literally and figuratively. Yes, it declared a break from the bonds with the king, but it also changed the political landscape of the world. The words, endowed by their Creator, changed the balance of power. Political power to this point in the world history was held by monarchs and dictators. But now, a new nation declared that rights were not derived from monarchs, but were rights of humanity that flowed directly from God the Creator. The people declared that all political power resides in the people and not in dictators and not in monarchs. Our founding fathers pledged their lives, their fortunes, and their sacred honor in support of this declaration, a declaration that was premised on their Christian roots. This takes me to my final thoughts, which I will set up by telling you about my dog, Tippy. Admittedly, I feed Tippy too much food. I cannot take the puppy stare while I'm eating, so I feed Tippy part of my meal as well as his own. At a recent family event, my brother-in-law rightfully announced that Tippy is too fat. My daughter immediately rebuked him, sternly stating, "Do not fat shame my dog." But my brother-in-law was correct. Tippy needs to eat less and move more. Why was it wrong to point that out? Why do I mention my overweight dog? Because I think a good many people today are faith-shamed from expressing their values in the public square. Sadly, all too often people of faith give up their firmly held moral beliefs because they've been trained to believe you should not discuss your moral beliefs in the public square. This is wrong. People of faith must be confident in their First Amendment right to free speech. They have every right to stand up and speak out for those things in which they believe. Oftentimes we're told we must hide our faith because we have separation of church and state. The separation of church and state is an important concept, one that should not be misused to silence diverse views. It is a concept that has been misunderstood, much like the original Second Amendment was misunderstood and sat dormant for nearly 200 years, until young Gregory Watson brought it back to life. Let's take a moment to examine the origins of the phrase. To begin, the religious liberty provision in the First Amendment consists of 16 words. Congress shall make no law respecting the establishment of religion or prohibiting the free exercise thereof. Nowhere in the Constitution will you find the words separation of church and state. The phrase comes from correspondence from Thomas Jefferson, then president, to the Baptists of Danbury, Connecticut, a minority religion in Connecticut, a state that endorsed Congregationalism as the state religion. While in the Virginia legislature, Jefferson authored the Virginia Freedom of Religion Act, and he was an outspoken opponent to endorsed state religions. The Baptists wrote to Jefferson to explain their plight in Connecticut and to thank him for his stance on religious liberty. Jefferson responded by observing the protections of the First Amendment and noting that the First Amendment erects a wall of separation between church and state. Jefferson was not in any way suggesting that the public policy preferences of religious people must not enter the public debate. It should not be lost on anyone that Jefferson was responding to a letter from a congregation of religious people who were appealing to the President of the United States for their religious liberty. Taken in proper context, Jefferson meant that the federal Constitution precludes the endorsement of religion. Jefferson envisioned a day when the same might apply to individual states. And in fact, in 1818, the Connecticut Constitution was so amended. The First Amendment was written to keep the government from endorsing a particular religion, while permitting people of diverse faiths the ability to freely practice the religion of their choice. Nothing in the First Amendment requires our public policies to be free of our deeply held moral and religious values. Think about this when you are told it is taboo to mix religion and politics. It is no surprise that religion and politics can be extremely polarizing. Both deal with issues that are of the utmost importance to a civil society. Religious beliefs and political beliefs reflect matters deeply personal to the one who holds them. They reflect one's value system and way of life. To be frank, it would be surprising to me if such matters were not polarizing. All too often, people of faith are told not to speak their political views because they are intertwined with their religious beliefs. But there's often a hidden message when people demand that people of faith not mix religion with politics. What they really mean to say is, don't expose me to your value system. In other words, hide your faith and your values within the four walls of your place of worship. The Supreme Court of the United States has struggled with the tension between the right to free speech, the Establishment Clause, and the right of each person to freely exercise or not exercise the religion of his or her choice. But the Supreme Court of the United States has never declared that there must be a total disconnect between the government and religion. Indeed, the Supreme Court of the United States opens court with the words, "God save the United States and this honorable court." Engraved in a stone above the head of the Chief Justice is a tablet representing the Ten Commandments. The United States Congress opens its session with prayer, as does the Michigan legislature. The First Amendment ensures both that the government does not show preference to a certain religion and that the government does not take away an individual's ability to exercise religion. In other words, the church should not rule over the state, and the state cannot rule over the church. That said, people should not feel ashamed to exercise their free speech right to opine on the significant policy questions of the day. That your policy preferences are consistent with your faith is nothing to be ashamed of. From the time of our founding, people of sound moral character have implemented policies consistent with their moral and religious beliefs, and we should not stop now. You need not be disagreeable to disagree with those who do not share your values. That people opposed to your morals and beliefs are intolerant of your views should not deter you from advancing your preferred policy choices. Intolerance of another's sincerely held beliefs, particularly when those beliefs are grounded in one's faith, is not a legal requirement. Rather, it is the unfortunate personal choice of those who disagree with you. In sum, the First Amendment does not banish debates that involve religious beliefs from the public square. To the contrary, the First Amendment guarantees the freedom for people of faith to have those debates. People of faith should speak their minds. Our founders would expect nothing less. Thank you.
Thank you, Justice. We'd like to pass a free will offering around before we ask questions, and a few housekeeping duties while we do that, okay? We have two sponsors tonight. So the first one has been with us since we've started, and it's the Catholic Foundation of Michigan. And they inspire charitable giving and assist donors in providing for long-term needs of Catholic parishes, schools, ministries, nonprofit organizations in Southeast Michigan. We have another one tonight, the Catholic Funeral and Cemetery Services. And its mission is to provide guidance and wisdom on end-of-life services. So they're here with a table, and planning ahead is a great gift of love for your family.
Jack, let me just start by, I want to say a great inspiration and resource for my remarks tonight came from a book in their own words, written by Michigan Court of Appeals Judge Mark Boonstra. He spent many years writing this book, and I purchased it in the winter, and it really inspired me to come up with these remarks tonight. It's a wonderful book documenting the faith of our founders, and the book has a website. It's called foundersownwords.com, or you can email Judge Boonstra at foundersownwords@gmail.com. He's a wonderful man and loves taking up discussion of these issues.
All right, one more thing, then we'll ask questions. Our next speaker is on a Tuesday night, June 7th. Father Mike Schmitz is coming from Duluth, Minnesota. He's known as the podcast king. His podcast, The Bible in a Year, 363 episodes, is the #1 ranked podcast in the world. So with that, any questions? Yes, sir.
How do you think the tax code impacts the practice of religion and the way religion is viewed in the courts in this country now and over the last couple of hundred years?
So give me some more context to that, because I've never really considered the tax code and religion, and I know that for the most part, religious entities are exempt from the tax code. So can you give me some more?
Churches are tax-free. Do you think that impacts how courts make decisions, how laws are made because they're tax-free versus taxable?
I do not. I've tried to study and look at the history of how the Supreme Court has dealt with the religious liberty provisions of the First Amendment, and I don't see any tie between that and how they're treated under the tax code. But there might be something implicit in there that I'm missing.
So thank you very much for your commentary. You know, in hearing this about the Founding Fathers, it's very reassuring. But the question is, how did we get off track? How is it that in public schools you can't even have a moment of silence? How is it that, you know, I think there's a case right now at the U.S. Supreme Court about a football coach who takes a knee and, you know, having prayer by himself, doesn't have the students come out. I just, like, was there a point with the U.S. Supreme Court that, you know, there was a liberal court? I mean, I just feel like what you're saying doesn't look like our society today.
Well, what I'm saying is that voters, people of faith who happen to be good citizens, should go out there and advocate for principles in which they believe. And the First Amendment free exercise clause and the Establishment Clause shouldn't make you think that you can't do that, right? The First Amendment guarantees free speech and religious liberty. And when it comes to political speech, that's the utmost protected speech. And I think the point of my remarks is I think many times people want to stifle speech that is consistent with religious values because they don't want to hear about religious values. They want to hear about moral values. And it's okay that they don't want to hear that, but they shouldn't stifle others from speaking it, right? We get on the soapbox and people stand up and they make their debates, and the First Amendment guarantees that thoughtful and vigorous debate will bring about clear thinking amongst the masses. We won't all agree. We'll never all agree on anything. But what's important is what 51% of the people think, right? Or 50.1 at election time. As it relates to the Supreme Court, I truly meant when I said they struggle. The Supreme Court has struggled with religious liberty for quite some time. And they've created tests, and then they back off the test. And one thing that they haven't really focused on is the actual language of the First Amendment, and perhaps they will down the road. But it's not been all losses for people who promote religious freedom and a less vigorous enforcement of current jurisprudence under the Establishment Clause. You know, when it comes to school, I think they've been a little bit more cautious than they are in other areas. But it's been a mixed bag on that front over the past, I'm going to say, 20 years.
Any others? While I'm walking there, Justice,
And I'll
the
take
first time we
questions.
had breakfast, you said, Jack, the word judge is both a noun and a verb. Please.
Okay, so what I said is I view judges as two types of judges. There are judges, the noun, and that is where they are the center of the focus. The noun is the focus of the conversation, right? And then there's judges, the verb, it's the action. There are some judges I've encountered, and I won't name any names, that feel it's very important that everybody stand up for them, and that they are known as the judge, and that they get the best table in the restaurant. Those are the ones I call judges, the noun. But then there are judges the verb, those that are sincerely concerned most about the function of judging. How is it that when you have a dispute, you go through the function of judging? And I like to live my professional political life as always thinking I'm the judge, the verb. It doesn't matter to me the robe or the title. It's about the function of how I come to decisions, and is there equal equity under the law in the decisions that I reach.
Hi.
Hello.
Thank you for your talk. This gentleman here, his dad, turned around and informed me the other day that the YMCA is not called the YMCA anymore, and the crosses have been taken down because it gets federal monies that they're now supporting no religion, and by supporting no religion, that is a religion. Do you know what I mean? So I know Hillsdale takes donations. So it's kind of like if you're taxing people, you're limiting the donations and the freedom of speech and the freedom of religion and the freedom of expressing that religion. So my question is, what's this all about? You know, I mean, was informed about this, and the YMCA has been important to me in the beginning of my vocation, and to find out about it is just, you know, kind of devastating for me.
So some things aren't all legal questions, some things become political questions. But let me start by saying you mentioned Hillsdale. I want to mention that I am a proud father of a Hillsdale student. My son's receiving an excellent education there. I think they've got a wonderful mission. We have Michael Murray from Hillsdale College right here, who does great work for them. But back to my answer. Some things are political and some things are legal. And if the YMCA wants to take it to court to litigate, it becomes a legal question. But I suspect this is now a political question for them. And it may well be that, you know, it all depends on who's in power. And the executive branch controls the Department of Justice, and the Department of Justice might come in and say, you know, we've got concerns about this or that, we want you to do these things, and then they'll strike a political deal. So I don't know the specifics of that. I'm unaware of any cases that were filed. They told us to take the cross down. We don't want to take it down. Must we take it down? Is this an abridgment of the First Amendment?
Well, for
So,
me-
I mean, you know, it's expensive to litigate things, and sometimes organizations just decide that we can't afford a fight, and they'll strike a political deal.
Well, I'm just saying it appears to me that that's limiting my freedom of speech and my freedom to express my religion, isn't it?
You have a freedom to express your religion. You have your freedom to express your views. You can go in and tell the YMCA that you are no longer going to support them because they've taken this stance. I mean, there's so much you have the right to stand up and speak about. And the point of my remarks tonight, I just encourage speech. I want speech from both sides, because I think when the debate is fully developed, the tradition of our country will carry the day.
Yeah, I like the elephant, you know, the memory of an elephant, that kind of thing. And I love the donkey for, you know, I guess if you combine them, you know, you got a good memory that I'm an ass. And the good Lord was carried, you know, Mother Mary was carried, you know, by an ass like us. So, thank you so much.
I'm a nonpartisan. I like to take votes from both donkeys and elephants.
Is there any legal definition of a human being?
I'm sorry, I couldn't quite.
Is there any legal definition of what a human being is?
Of what?
A human being is.
Oh,
Who's human, who isn't under the law?
you know, I guess it would all depend on the legal context. I'm sure that if we scoured the case law and the statutes that we'd find something, but it all has to be put in context at the end of the day. And to the extent you're touching upon the life issue, it's all of a sudden become a very hotly contested, I don't even say contested, it's become an issue that has become more present at the state level. And there's litigation in front of our court right now that touches upon it, and so I'm going to exercise the right to not answer that, because I don't want to be accused of expressing judgments on any upcoming litigation.
Do you think then that the legislature should be addressing this question and making it?
Can you put the microphone aside and just let's hear what you have to say?
Do you think that the legislature should be addressing this question then and deciding?
Yes, absolutely. Absolutely. I'm not going to get into the specifics, but the battle in the life issue has been that Roe versus Wade took it away from the states. And if Roe is reversed, and it's not at this point, it may be, but if it is, it returns to the states. And so it's a question for the state legislature to battle out. And it'll be a very interesting battle. We'll see what happens.
Thank you so much for the time that you spent with us this evening. For most of us who are a non-legal profession, when the time comes at the level of voting for judicious individuals, how can we determine the one who's the noun or the verb?
I think that's a great question. So I've had that a question before, and I say it's imperative that people do their work. They generally know, and they go to the polls, and they know who they're going to vote for governor. They know who they're going to vote for president. They probably know who they're going to vote for their state House and state Senate. Really diligent people will also know their county commission, and they'll even know how they're going to vote on the various proposals that are on the ballot. But many people go in and have no idea about the judges, so you got to get that ballot early and then do some research. And what I suggest is you go to the websites. Every candidate has a website now. Go to the candidate's website, judicial candidate's website, and look for a statement of judicial philosophy. If they don't have a statement of judicial philosophy, that's probably someone you're not interested in voting for. If they have a statement of judicial philosophy, and the judicial philosophy is, I think judges should be fair and impartial, again, I'd respectfully say you should probably look for someone else. Of course, all judges should be fair and impartial. The question is, how do you think about cases? How do you think about the law? How do you go about deciding? That's what a judicial philosophy is. And so people who've thought hard and long about their judicial philosophy and aren't afraid to put it out there, by and large, are the verbs, I believe. And people who want to run and say, I'll be fair and impartial, are more interested in being judge than the function of judging. But at the end of the day, it's on everybody in here to research every judge, from Supreme Court to Court of Appeals to circuit, probate, and district. Because judges, when the time comes, judges can have a greater impact on your life than any president. And you just don't know until you're there. And then you can't turn back the hands of time to say, who did I vote for and why?
Right here.
Yes.
Hi. I heard that, I think it was in California, the people voted something and one judge didn't like the results, so he stopped it. Also in the government with the Senate and the Congress and everything, they give themselves raises. They don't participate in the health plans that the rest of us do. They get lifetime salaries, though they want to take our Social Security away for those of us who do that. Is there a way that we can put into law that those who are in government have to have the same insurance as us, have to have the same benefits as us, so that they can make proper decisions rather than, they give themselves, so, what do they care? Where their morals don't seem to be, well, they don't seem to have any. But, they put on the people, and if they know they have to put it on themselves, they might make better decisions. Is there a way that we can get something on a ballot to say that?
So you're talking at the federal level, which makes it much more difficult. But let me just start by saying the original Second Amendment, which passed as the 27th Amendment, says they can't give themselves a raise without standing for election. And so that's still in place as a check on when they give themselves raises. As it relates to them being required to take the same Social Security, I know they have their separate plans, they have their separate 401k plans. I understand all of this, and it is very frustrating. Can it happen in one election? No. But I'm sensing from the political tone that has existed over the past several election cycles that people are very tired. And there'll be a political, I mean, not like an American Revolution fighting in the streets, but there'll be a political revolt. I think we've come close a number of times. I think they were close in '94, they were close in 2010. It's been such a crazy past few cycles that I can see people uniting across the country to try to bring about some change. Specific to that, probably not to that specific issue, but I think a slate of people who will promise that here's what we promise to do if we get elected. And we want support across the country to do one of two things: take the House, take the Senate, take whatever at state or federal level, whoever may be in charge, and then a campaign on that slate. Something like that happened in 1994, was known as the Contract for America. You may be too young to know about that, but it brought about a wave, and there was some significant change in Washington, but it just didn't last.
What happens if
You're going to have the best question of the day. What's your name?
If the governor doesn't enforce the 1931 law, what happens?
If Roe v. Wade is overturned.
What happens?
Yeah.
It goes back. So if it is in fact overturned,
Mm-hmm.
then the question is returned to the states.
Mm-hmm.
And so there'll no longer be a federal prohibition, and every state will pass laws defining if they want abortion, and if so, on what terms.
What happens if the governor doesn't enforce the 1931 law?
What happens in Michigan?
That I can't talk about because it's in front of my court.
Oh.
Yeah.
Yes, Your Honor, I have a question. Here in Oakland County, we have a Sixth Circuit Court. We have a judge there who's been sanctioned. She's been put under penalty. They've had 150 attorneys line up and to go against what the sanction was. She was kept on the bench. She's been known to be unstable. She runs unopposed and yet sits there and continues to work as a noun judge. What do you do in a situation like that?
You know, that's a very specific question, and I'll talk to you when we're done, and I'll be able to
happy
get better
Thank you, Your
details
Honor.
from you.
Thank you.
Yeah.
Well, I'm going over there. Your Honor, if you took the robe off, Brian,
It's not on.
okay, and you went from behind the bench and became a partner of a law firm on the other side of the bench, you'd be 5, 6, 7 times wealthier overnight. Why do you keep doing this?
So I actually was a young partner in a very large Michigan law firm. It was Dickinson Wright, as it's known today. Then it was Dickinson Wright, Moon, Van Dusen, and Freeman. And I was a litigator, and as a young litigator, I became very frustrated at my inability to counsel my clients. Here's what the law says. Here's the motion I'm bringing. I think we should win the case, but I can't predict what the judge is going to do. That was very frustrating for me because it was unfair to my clients. I felt very inept as a lawyer, but there was not much more I could do. I went in front of a few very good judges, and without naming, most of them have gone and aren't on the bench anymore. Many, many other judges who were judges the now. And so I kind of decided early on that if I have the opportunity, I will try to make a difference in the judiciary. And that opportunity came for me when I was only 34 years old. Then Governor John Engler. I was an active Republican in Wayne County, and there weren't many of those. So when there were judicial openings in Wayne County, it was easier to get noticed. I was with a big law firm, and he offered me an opportunity to take the bench. So at 34 years old, I became a judge. And I felt very prepared at the time. I'd worked hard throughout my career, and I knew what my priorities were, to really focus on the law and make rulings based on the law and give every person who came into court a reason for my decisions, not require lawyers to be waiting in a courtroom for hours waiting for me. I actually set up a motion schedule that was unheard of at the time. It's only come into vogue with Zoom. Now people can have specific times, but I used to make specific times. On Friday motion day, I'd start at 8 o'clock. You're at 8, you're at 8:10, you're at 8:15, you're 8:25, you're 8:35. Bring them in, give them their time, and then they wouldn't have to waste time and their clients wouldn't have to pay for that. I was there for 4 years, and then Governor Engler put me on the Court of Appeals. At a recent investiture of another judge, Governor Engler was speaking and I was the MC, and I asked him, I said, Governor Engler, what were you thinking when you made me a judge at just 34 years old? And I said it as a joke, but without missing a beat, he said, I envisioned you being right where you are now in the Supreme Court, Brian. He appointed young people and gave them a chance to develop their careers. So I had that chance to be in the law firm, but I wanted to have a bigger impact in the law. My family might not appreciate that as much as I do, but I look back at my career and I'm blessed and would not do anything different.
Your Honor, thank you for all of your great remarks and history this evening. Speaking to your, how you mentioned our First Amendment rights and religion being an integral part of people's lives, we as private citizens have that First Amendment right and we cherish it, we speak our views and so forth. I find it very disturbing in our public square for public figures, particularly nomination of judges, but also other political figures, are being bludgeoned by the opposition using their religion against them. Why is there not more outcry against this type of, it's almost a form of discrimination. I feel it particularly targets Christians and Catholics, but to do it to anyone based on religion, it would be like saying you're not qualified because you're from Michigan, but it's even more it's deeper than that.
The dogma runs deep in you, if I remember the California senator to Judge Justice Cooney Barrett.
Yes.
So look I hope I got through the message tonight. My message is, you don't have to remain silent. You know, don't feel that you would be acting inappropriately if you want to speak up and say, you know, this is what I believe in. And if people are intolerant of you, it's their problem, not yours. All I ask is that people be civil. You don't have to be disagreeable to disagree. And we need to have these debates. But these debates have not been occurring. Why? People like to get hit over the head with a baseball bat and stand up and say, give me another, I guess. But it's just, you know, you have a right to speak in the public square. You should not be ashamed to speak your views. And people should do that. And if they don't, then you're going to get the country that you're asking for. So, you know, I don't know how the debate will fall, but all I'm saying is we need to have the debate. We need to have this vigorous debate. There's nothing to be ashamed of expressing what your values are. That they're consistent with your religious beliefs is nothing to be ashamed of. It's kind of the way this country was run for 200 years. Why is it that all of a sudden we can't think of these things now? So, it's speak up, don't support those who are insulting to you, and you know, elections have consequences. At the end of the day, it's a system where we go and we battle it out. We don't battle it out with fists, knives, or guns. We battle it out at the voting booth. And We accept the result that we get. Elections have consequences. But my call to action is really, people of faith shouldn't be ashamed to speak up. People of faith almost have a duty to speak up.
Whatever happened to the young man who got that, the amendment eventually passed? Did he end up being an attorney, a judge?
Gregory Watson?
Yeah.
Gregory Watson is now 60 years old. As far as I know, he never became an attorney. I tried to look him up to prepare for this in anticipation of that remark. But he does have a Wikipedia page, and I think he did get into public service of some sort, but not as an attorney and not in the practice of law by any way. Let me just say, the remarks I made to you about voting and people getting up to speak, and it's very uncomfortable for me in a Catholic church to be standing here saying these things. I went to St. Albert the Great grade school, Dearborn Divine Child High School. And my first election, I went to Baptist churches in the city of Detroit where they'd invite me up to speak from the pulpit. But in the Catholic Church, even mentioning that I happened to be sitting in the back of my church, and by the way, you can vote for Brian on Tuesday, was taboo. So this isn't a service. We're not violating any tax laws. But I think, being raised Catholic, there's a little bit of, we're kind of told just keep it to ourselves and be humble and put your head down. And I'm just saying, maybe we should think about these things a little bit differently.
The most used phrase in the Bible, 365 times in the Bible, is
Judge.
be not afraid.
Okay.
So what the justice is saying, we can do it civilly, but we've got to stand up for what we believe. This is the greatest country on the face of the earth. And we have the power to decide what's going to happen today and in the future.
I just wanted to say in support of what you've been talking about. I used to be one of those very silent people. I was raised to be a quiet lady and to not be argumentative. And 2 years ago, when a lot of these mandates and our rights were going away, I felt very called to speak up. I attended my first protest and have attended many protests since then. I have worked on petitions. I have spoken to groups and people, and it's much easier than you might think. And I have to tell you, I was terrified when I began because it was very outside my character. But to be honest, I don't want to stand before my Lord and God and say, I did nothing, and I allowed my faith in my church to be closed, and I allowed people to suffer and be enslaved. So thank you very much for saying all of that, because I don't want to be alone.
Thank you.
Are you going to run for political office, ma'am? You got a lot of votes. You got a lot of votes. Thank you. Thank you. Anybody else? This will be the toughest one, Your Honor. This will be the toughest
None
one
of
right
them
here.
have been easy, Jack.
I think so. Just as you were talking about the wall between church and state, and there's a apocryphal belief that that wall can never be penetrated. That's what apparently we Catholics have been told, or many of us have been told. And I think your message is, this is a real short wall. It isn't any big barrier. Am I right? We go back supporting religion all the way to the days of the Northwest Ordinance.
So my research in preparing for this, I found the biggest conflict of religion in early America arose from the establishment of religion. And the Pilgrims and colonists came because of religious persecution. They wanted to get away from that and have religious liberty and freedom. And the whole idea of establishment, the government shall not establish a state religion, couldn't be said alone without Madison also guaranteeing that you have the right to freely exercise your religion. So I'm sure he was thinking, well, if we say there's no state-endorsed religion, but then all of a sudden the state starts quashing religions that they don't particularly care for or any religious belief. So it was a twofold thing. It was, we shall not have state-established religion, and we shall not preclude anybody from freely practicing any religion or no religion. It's their free choice, right? That's the free exercise clause. The wall, as I said, came from this correspondence from President Jefferson, who, by the way, was in Paris when the First Amendment was drafted and ratified. So he didn't participate in its drafting, was able to give us any real understanding. But again, if you take it in context, the conflict in early America was we got to get away from this establishing a government church. And that's where the wall is. The wall is keep the government out of religion. And that's, I guess, the point, right? Let's focus on what the First Amendment says. Free exercise of religion and no established state religion. This wall, when we look at the comments of Jefferson to the Danbury Baptists of Connecticut, really related to his understanding of their plight in Connecticut, where they were being oppressed. I'd like, if you take away anything tonight, I'd like you to focus not on the wall of separation between church and state. I'd rather you focus on the 16 words of the First Amendment that guarantees that there will be no established religion and that there will be the free exercise of people to any religion or no religion. Yes, sir.
All right. Now, I want to start off by saying that I am, more than anything, a very strong supporter of equality in rights and in beliefs. But one of the things that I have actually personally been accused of was not it, and it felt weird because there was a African American man that came up to me and said, he asked me if I was Christian, and I said yes, and he said that then I should believe in equality, and I told him that that is a given for me. And then he started to talk about a lot of different types of groups that, at least in my personal opinion, seem to be sort of self-segregation type groups. So how would I go about addressing that?
So, look, what I want is open debate and respectful debate. And so there's a way of saying respectfully, you know, I have Christian values and I want to love my fellow man and love my neighbor as myself and act in the way Christ acted. I believe I am someone who believes in equality, but let me just share with you how I feel when I hear about this group. I think that this group really isn't talking about equality, they're talking about exclusion. Can you help me understand your position with this group? And just have open debate. And you know what? It's okay. I've had these debates with a lot of people. And sometimes we just agree to disagree. But I feel better because I had this debate. I don't possess anger or vitriol because people disagree with me. Again, you know, let's try to air it all out and let the better arguments prevail. But when people become frustrated with me or they start calling me names or they're intolerant of my views, okay, that's not on me. That's on them. And I request them to keep it respectful and just move on from there. But the point is, let's talk about it. Let's not keep it under the sheets.
Thank you.
All right. We have carrot cake as usual.
I heard there's carrot cake.
So please join us in the Freedom Hall. All right? Thanks for coming. Your Honor, thank you.
Thank you for being here. Yeah, I know. I remember seeing you last month. And it was God intervening. He rained out your game, right?
No,
Okay.
exactly.
Well, thank you both for being here.
Yeah, thank you.
Judge, I